Welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All.
Hello and welcome to Empowering Workers, Federal Employees' Disability and Employment Rights and Social Security Disability for All with Eric L. Pines. Eric is a nationally recognized federal employment lawyer, mediator, and attorney business coach. He represents federal employees and acts as an in-house counsel for over 50,000 federal employees through his work as a federal employee labor union representative, and he also represents all Americans who need Social Security disability. I am your host, Kevin Rosenquist, and today's episode is Supporting VA Doctors and Nurses, a Guide to Representation, Reasonable Accommodations, and Disability Retirement. Eric, welcome back.
Hi, Kevin. It's great to see you again.
To kick things off, can you explain in your experience representing VA doctors and nurses or Title 38 employees?
You would think that representing every federal employee would be the same, but you wouldn't be correct. Interestingly, there are different ways that a federal employee could be hired. To hire a federal employee, you need a federal statute to authorize that. The typical federal employee is hired under the authority of Title V, which is the statute. And so about 95% of employees are under that. And that's basically that's the gist of what federal employee law is. They have the same court systems. Generally, they have the same administrative law systems. Everything's done the same. The VA is very unique. The VA actually has three categories of employees. They have this Title V employees. They have something called Title 38 employees, which is what we're going to talk about today, what you're asking about. These are people who are hired under Title 38. Interestingly, based on the research I did, Title 38 was created after World War II, I think, or World War I. It was World War II, though. The VA was having trouble hiring medical professionals after the war, so they needed to compete with the private sector. So to get the rights to hire people in the private sector and to have the financial wherewithal to compete, I should say, with the private sector, Title 38 was enacted. That's the good news. More money was there, more hiring was done. The bad news is there was a trade-off, and that trade-off was laws and rules and regulations that protect these employees. So these Title 38 employees, who generally are on the larger category, doctors and nurses, or medical professionals who are actual professionals, they have their own laws, rules, and regulations. So I would just say that if, let's say, only a handful of attorneys understand federal employee law, which is very unique, there's only basically a few fingers of attorneys out there that actually represent and understand Title 38 law. So that's the gist of it. I would just say the interesting thing is, just to confuse you a little bit more.
Nice.
There's a middle class called the hybrid Title 38s. These people are part Title 5s and part Title 38s. They're hybrids and they get amazing gas mileage. No, I'm just kidding. That's completely irrelevant. But no, they're hybrids. So what does that mean that they're hybrids? It means that basically they have a lot of the protections of a Title 5 employee. Well, I should say it means they're in some type of medical profession that's halfway between being a regular Title 5 office worker type position and halfway between a medical professional, like a tech of some sort, medical tech of some sort. So they have some of the rights of Title V, which is great. They've got a lot stronger protections, but they don't have all of the rights of Title V. In general, I find that they mostly fall into the category of Title V. But once again, you need to know if you're a VA employee, if you're Title 38, Title V, or a hybrid 38.
And how often are accommodation requests for VA doctors and nurses granted?
Okay, so that's a great question. So I happen to have a passion for reasonable accommodation for federal employees. So the question stems from the fact that many times I have people reach out to me who need an accommodation who are doctors and nurses. One of the main accommodations, just to answer your question directly, that I'll see, and I see it a lot, is the VA likes to, I don't know if they like to, I should say they're forced to, it's not their fault, but they're forced to overwhelm their doctors and nurses because the VA is the largest federal agency and they have so many patients that need to be treated, but only so much money to hire doctors and nurses. So what happens is that these doctors and nurses become overloaded with tons and tons of patients. So they have to see the patients and they also have to take notes after they see the patients to put in the file. All these things make complete logical sense, and we certainly wouldn't want the VA not to require those things. The problem, of course, is that when you have tons and tons and tons of patients, more than you're supposed to have, and you have to take notes, the regular, 8-hour, 10-hour day is not going to be enough to get it done. So a lot of times I'll be approached by VA doctors or nurses, or mostly doctors, who will say, I need an accommodation. I have ADHD, or I need an accommodation because of some stress related thing, because I can't get all my notes done. I need some time to be able to do them. I find that that's a very popular accommodation. So to answer your question, it happens a lot. We're approached, I would say, at least monthly with a different person, a different medical professional at the VA who needs accommodation to assist them to do the essential functions of their job.
My father is actually dealing with the VA right now for some medical stuff, and he's it's going all right. But yeah, I can tell it's complicated, and they're definitely overworked, because it's hard to get appointments, it's hard to get follow-ups and stuff, and it's not that they're being lazy, it's just that they're overworked.
100%.
Yeah.
I would say, just to take it a step further, the people who I've represented and I represent a lot of labor unions, which means I physically go into the unions. When I say labor, I mean particularly federal employee VA unions. I go into the office and I meet with people in person and give them legal advice. So I'm in the VA at least 2 to 3 times a month, different VAs from Las Vegas to Houston. And I see these. We hear a lot of bad things about the VA. Let's be honest. We hear a lot of bad things about federal employees, but these people give their heart and soul, and they're just in an environment where the funds are limited. Look, they're not perfect. Of course, no one's perfect, and there are some scandals. We see them all over the web, whatever, all over the news. But the reality of the situation is the system is really, it's all the people involved, I truly believe, mean well. Whether it's the labor unions, whether it's the directors, whether it's the actual people we're talking about now, the employees, they all care and they all mean well, but the system is overwhelmed and overworked, and it ends up basically leading people to have to reach out to people like me.
Well, how does Title 38 affect the employment rights of VA doctors and nurses?
Let's go back for a second to what we were just saying. You were saying when it comes to reasonable accommodation, or we'll talk about maybe disability retirement, it does not affect it at all. That's the good news. That's the good news, because reasonable accommodation is protected by EEO, Equal Employment Opportunity Commission, or EEO, Equal Employee Opportunity. There's a federal agency that is an administrative court that we can turn to, and there are the federal laws. Those same laws apply to federal employees like non-federal employees. So when it comes to reasonable accommodation, which is protected by the Rehabilitation Act, which is the ADA for federal employees, no difference whatsoever. They're entitled to a benefit. And if you listen to one of my previous podcasts, I talk about how I love doing reasonable accommodation cases because the laws are really on the employee's side. That goes just as well for federal VA Title 38 employees. The law is on their side for those accommodations. Of course, we might bump into a problem because, let's say, it is an essential function of your job to take notes. We talked about that a little earlier. So you kind of have to figure out what's reasonable as far as accommodating them when it comes to notes and stuff. But just to answer the question specifically, it does not affect them at all when it comes to asserting EEO rights. It does not affect them at all when it comes to asserting whistleblower rights, which is something we assist with as well under the Whistleblower Protection Act, which goes before the Office of Special Counsel, or the MSPB. It doesn't affect them. They're treated just like everybody else. However, the buck stops there. When it comes to disciplinary actions, which would normally go before a court, which we talked about before, called the MSPB, they cannot go to the MSPB. That's where I was saying earlier that they don't have the same rights as other people. The MSPB is a great protection. They cannot protect those rights in front of the MSPB. The only way they can get into this MSPB, and we're talking about if they're fired or demoted, is to file a whistleblower case and get in through that way. And that's obviously not always so simple, and that takes time, and you have to have the facts of a whistleblower case. So to answer your question quickly, the big changes come when it comes to disciplinary actions. And so that being said, it's not that they have no rights whatsoever, and that's why we have a little specialty. I wouldn't say we're specialists, because I know the bar doesn't like to use the term specialist, but we have a lot of experience, more than, like I said, more than the typical firm, and probably amongst maybe 2 or 3 firms in the country, that understand that these VA medical doctors, if they are disciplined for something that relates to patient care, they have their own special court system just for them, which is a court of their peers called the Disciplinary Appeals Board, DAB. So where basically 3 people in their position are called together and a labor relations professional, and they sit down and they have like a little mini administrative trial where they can hopefully, with our assistance or other firms' assistance, they can try to prove that what they did not breach the standard of care and get the disciplinary action taken away.
Okay. And can you kind of walk us through the typical steps a VA healthcare worker should take to request a reasonable accommodation?
Sure. Very similar to what for any federal employee, basically step one. Well, here's the beauty. I actually was in a seminar yesterday about reasonable accommodation. And one of the things they really hit on is that you don't even have to request reasonable accommodation. In fact, one of the questions on the test was, on the hypothetical. I'm not back in school yet, but the hypothetical was, let's say a blind person is sitting there. Actually, that's not the best example, but let's say somebody is sitting there who has trouble hearing, but it's not so open and obvious that everybody would know. The coworker says to the supervisor, Bob's really having trouble hearing. Bob didn't say a word. That is considered a request for reasonable accommodation under the law. Oh. That's how lenient it is. Wow. Now, it could be Bob doesn't want to be accommodated, which is a question I asked yesterday. And of course, he can say, no need. You don't have to accommodate me. But that's not what we're talking about. We're talking about the agency was on notice, and they needed to process that as a reasonable accommodation, which is crazy if you think about it. It doesn't even need to come from the employee. And then, okay, so
they still have to process it?
They still
even though
have
it didn't
to
come
process
from. Wow,
that is exactly right. Now, somebody needs to enforce that and sue. Sure. Maybe Bob would never sue, and it would never happen. But technically, under the law, that's how strong the law is pro-employee. And then let's say Bob sits down to the desk, and he's blind, and he has a walker, or he has a seeing eye dog, or he has one of those sticks. Like, it's clear to everyone that he's blind. Obviously, a supervisor knows he's blind, but for this hypothetical, let's say he gets a new supervisor. So if something's in writing and it's not there in Braille, Bob does not need to request it. The reasonable accommodation is open and obvious, and the agency must work to try and get him accommodated. So that's how lenient it can be. That being said, that's not what usually happens. What usually happens is somebody needs to call that request of accommodation to the supervisor. They can go to their supervisor. They can go to their supervisor's supervisor. They could go to the director if it's the VA. They could go to the reasonable accommodation office. They could write a letter to the EEO office, which is usually called ORM in the VA. So to make a long story short, it's either open and obvious, someone requests it, or they themselves request it, but that it's extremely lenient to get the ball rolling, where the VA has to, or the federal agency has to engage them in what's called the interactive process to get back to them and have a discussion of what accommodation would work for them.
Okay. And what if that request is denied? What legal options do VA healthcare workers have?
Great question, because there's a lot of segments of that. Number one is the first step is to go, there should be a back and forth. The law calls that the interactive process. There should really be a back and forth. If it's denied, they'll generally come back and they'll either give you something that they think is an accommodation for you, or they'll say they need more medical evidence, assuming they're doing the right thing. So let's say one of those two things happen. If they say they need more medical evidence, then the question is really, if it's open and obvious, they're wrong. And you could file an EEO case, which we'll talk about in a second. But if they're right, let's say it's like a psychological disability, which is not openly visible, you probably will have to provide them with medical proof from a doctor that you have a disability. And again, something even crazier about the protections of disability rights is the doctor does not have to say what your disability is. The doctor just has to say, like, let's say you don't want them to know that you are manic depressive. The doctor could just say, I treat this person, they have a legitimate medical condition, and they need this accommodation. And that under the law is good enough. So, okay, so that's one way to do it. Let's say moving to that hypothetical that they are denied, or the agency just doesn't do what they're supposed to do. Then they can go to ORM, or they could go to their local EEO office if they work for a different agency, and they can file what's called a EEO informal complaint for failure to accommodate for disability reasons.
Okay. Can you share an example of how your firm has successfully represented a VA doctor or nurse in securing a reasonable accommodation?
Most of the time, I would say about 80 to 90% of the time we're successful, because as I said, the law is on the employee side. Generally, they'll request an accommodation with our assistance, and we'll be there to be involved in the interactive process. And the VA will come up with something. For example, I've had an employee let's go back to our previous hypothetical, and I must have had 3 or 4 of these people. I have one now. We've gotten the employee more time to do their notes, even though let's say the notes are due by the end of the business day or the end of the week. We've gotten them an extra month to catch up on notes. We've gotten them a note taker. We've gotten them Dragon naturally speaking software. I don't think that even exists anymore. I just dated myself. Probably you just have to talk and your phone's listening to you anyway. So
that's true.
But in the past, we've gotten them Dragon naturally speaking. You can get some type of transcribe. So I'll just tell you, I had a case years ago, not in the VA, but it's a fascinating case where somebody had epilepsy, and when the flicker of the fluorescent lights occurred while he was working, he would have seizures. So,
oh, wow.
So the agency had to build him an office. And this wasn't even their building. This was a rented building. But the law is so strong, they had to build him an office that had different lights in it within the building that they were renting from. So the law is really strong. I do want to point something out before, so I don't leave people with a misconception. This is really, really crazy and important. But you do not get to pick your accommodation. You can try, you can request your accommodation. So, and I've been saying up until this point that the law is really on your side. But all that needs to be is all the agency needs to do is provide you with an effective accommodation. And they can pick the accommodation for you if it's effective. Now, you can, of course, argue that, no, this is not effective. And that's usually what happens if the person doesn't like the accommodation that the agency gives them. But you don't get to, you can ask for an accommodation, but you can't sue them because they don't choose the accommodation that you particularly want if they give you what the law considers as an effective accommodation.
Okay. Yeah, that makes sense. You can try to request something, but there's no guarantees.
Right. Exactly.
Yeah, gotcha. How does your firm advocate for disabled VA employees, and what resources do you offer to ensure their rights are fully protected throughout the process?
A few ways. Number one is you don't have to hire us. Well, I would say let me put it in three categories. There's people who just come to our website, and our website is filled with at least 15, 20 years of me blogging or having blogs that I liked that relate to teach people about reasonable accommodation, teach people about being VA doctors and nurses, whether they need accommodation or not. I should just say the website is a treasure trove. So that's one way. They don't need to hire us. They could just check out the information. We're glad to. That's the beauty of Google and the web is a lot of materials in this world have been democratized and people gain from your knowledge. And that's an amazing thing. If we could make that difference, if a person can't afford an attorney, could learn so much just from the website. But then there's the middle category. Let's say, so our firm generally charges not for disability retirement. We don't charge anything to review your case for disability retirement because that's a flat fee. But if somebody were to come to us and want us to represent them on an hourly basis, we will charge for a review. And we charge for a review because we want to spend 1 solid hour reviewing your documentation. And hopefully you'll write up something in your own words in addition to the documentation. And then we want to spend 1 solid hour basically educating you like I'm educating you now on your particular case. And I would say at least 50% of the time, we're telling people not to hire us. Here's how you do it yourself. And so one way is to basically just pay for that case review with us and save yourself the trouble of finding an attorney who might be unscrupulous and not tell you how hard it is to win this type of case in particular, and get the education to do it yourself. And then if you get stuck and maybe it looks like you're going to settle, then maybe come back to the attorney. So that's one way, that there's that case review. Or let's just say you have a great case and you just don't want to pay the attorney, but you do want to know how to do it yourself. Come to us and just do that review. That's one way we can assist you. You've got 2 hours of our time, an hour to review, an hour to talk, and we're not sticklers. If it's a few minutes over, we'll talk to you. We really want to help you and teach you and protect you and help you learn what to do on your own. So that's one way to do it. The last way is basically to hire us, and we will be your advocate, right-hand people. We will do everything for you. Once you hire an attorney, the agency is not even supposed to talk to you. Your supervisor can talk to you, but the EO office can't talk to you. No one can talk to you. They have to talk to your attorney. We're basically your defense. We're your defenders. We're your offensive line. And we're there basically to protect you, to take care of you, and to reduce the stress and to fight for you. And we will do that through all the way from the beginning of accommodation process through working with the judge to a hearing if process. And if you have to appeal, we would do the appeal. So those are the main ways that we assist you. Those 3 ways, from just free look at the website, please learn, to here's a quick primer to teach you how to do it yourself or to tell you whether it makes sense to hire an attorney, to finally, we'll hold your hand, represent you. And I'll say one last thing. If you have a really strong case, and many people who have legitimate disabilities and need accommodation do have strong cases, if we are able to settle your case for attorney's fees, we can get you paid back everything you paid us. So it's really, if you have the money, not much of a risk if you have a very strong case, because you'll end up getting paid. You'll end up getting paid back the attorney's fees. So that's another thing to keep in mind when you reach out to an attorney as well.
Absolutely. Yeah, that's great. Well, thank you for tuning into Empowering Workers, Federal Employees' Disability and Employment Rights, and Social Security Disability for All with Eric L. Pines. To connect with Eric, head to pinesfederal.com, and please be sure to like and subscribe to our channel and leave us a review in the comments. Eric, it's always great to chat with you. Thanks so much for coming here and chatting with us.
Appreciate you. It's been a pleasure as well. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.